Why do you need to take Mr. Martin's deposition?
I want to know whether that was actually any of it was him or not.
Why do you want to take Ms. Beatty's deposition?
Ms. Beatty is actually listed in the initial disclosures. The defendant is admitting that this lady has discoverable information, which means I should be able to depose her.
I know Mr. Garcia is representing himself. He's not licensed in the state of Michigan, as I understand it, but he is an attorney in another state, and attorneys generally can sort those things out by way of phone calls. I don't know. I mean, you're familiar with the phrase too clever by half?
I do, Your Honor.
That's sort of what I thought of your argument about that. Like, you could pick up the phone and solve that issue with Mr. Martin too, right? And said, hey, you don't mean I mean you. Garcia v. Mariana Enterprises, LLC. It's file 25-9166CK. Counsel, please state your appearances.
Good afternoon, Your Honor. Steve Garcia, appearing as pro se.
Okay.
Good afternoon, Your Honor. Dan Martin. I'm appearing on behalf of the defendant, Dale. Our dryer is right here to my right.
Good afternoon. And Mr. Martin, you have two motions up, one for a second motion for summary disposition and the other one to strike a notice of deposition. Let's take the summary disposition first.
Very good.
Excuse me. Did you say that there was a reply brief that's been filed?
No, I didn't see a reply brief.
Thank you.
No, I just said I reviewed his brief and your response. Yeah.
Your Honor, this motion turns on three dispositive issues. We filed this under C8 and C10. It is the responsibility of the opposing party under 2.116G to provide legally admissible evidence to give rise to an issue in dispute. In this case, the documents submitted by the plaintiff are legally inadmissible. Exhibit 1 is the contract, and that's fine. Exhibits 2, 3, and 5 are legally admissible. 2 and 3 are correspondence between the parties in the course of compromise and settlement, which is banned under MRA 408. These are inadmissible communications, and they should be stricken from the court's consideration.
Well, I mean, you might be. So let's even say you're right about that. What's Mr. Garcia to do when part of your argument is that he has failed to mitigate his damages by failing to accept your client's offer to go out and repair some things, and then he's trying to document that, well, that was only to repair certain things that were storm damage. They were not to repair the previous breaches I'd complained about. I mean, he's entitled to clarify that in response to your argument, isn't he?
Well, those were sent in 2024 before the ice storm. So they would be legally irrelevant as well. And Exhibit 5 is the May 2025, which is the post-storm letter where he called and screaming at my client, and they're like, we'll go out, take a look at it. That is inadmissible under remedial measures evidence rule, MRA 407.
Well, I mean, it seems to me you can't have your cake and eat it. That if you're going to argue that he failed to mitigate the damages, or that then he's entitled to present some evidence that wouldn't have mitigated the damages.
Well, I don't think that has to do with mitigation. What he's submitting it for is admissions of breach.
Oh, well, yeah, then 2024 stuff. Well, yeah, wouldn't that be admissible?
That would not be, because communications made in the course of settlement and compromise are inadmissible.
Well, he didn't. He sent an email, or he sent a letter saying, hey, you agreed to do these things. You didn't do these things. What are you going to do to make them right? That's not an offer to settle. That's somebody communicating like, hey, there's a breach here. What are you going to do? And then when they reply and say, yeah, we acknowledge some breaches, it seems to me that would be entirely admissible.
Well, for purposes of determining whether or not there's an admission of breach, would not be admissible. If the court's right in terms of mitigation, then offer was made to mitigate and he failed to take advantage of that. That goes to our argument that plaintiff failed to mitigate his damages.
Can I ask you, my principal issue with your motion is you make several assertions of fact about, for example, when the work began and when it was finished, assertions of fact that the that the defendant inspected storm damage and offered to repair it free of charge. And then even more importantly, assertions of fact that the plaintiff gave directions regarding the termination point of the shoreline and preservation of the trees, and the defendant did the work in accordance with those instructions. So therefore they can't be liable for any breach for that. But as best I can tell, not a single one of those factual assertions have a citation to record evidence. And wouldn't that be required for you to obtain summary disposition?
Well, under Exhibit 2 of the plaintiff's response, he acknowledges that work started August 17th and ended on or about August 26, 2024.
Right, but I mean, you were talking about, plaintiff's burden in response to your motion, but really, I'm concerned about whether you met your burden in your motion.
Well, then I'll address the legal part of it under C8, Your Honor.
Okay.
And that is in the contract, as for counts 1 through 5 and 6 through 7, those are barred by virtue of the disclaimer in the contract that all work on the shoreline are not warranted. And that's done, Your Honor, to negotiate and the risk of weather, acts of God, and storms. And that forecloses movement on any of his 7 counts as a matter of law. It is an express disclaimer of warranties on or damages on any shoreline work. And that's what this contract was premised on, shoreline. He cannot make any claims. No contractor would enter into an agreement if their risk is subject to acts of God, storms, of that nature, because... But
isn't a warranty different from a claim for breach of contract? I mean, if I buy a car and I have a contract to buy an all-wheel drive vehicle, and let's say they sell me a vehicle and the contract disclaims any warranties for that vehicle, but the vehicle they sold me wasn't all-wheel drive. Despite the disclaimer for warranty, I can sue for breach, can't I? I mean, those are two different legal theories. One is a breach of an express term in a contract.
Well, I think that's probably apples and oranges, because what your analogy is as to goods. And under the UCC, you have warranties as to fitness and
okay, fair enough.
Workmanship. This is a service contract. And the Michigan case laws that I've cited state that you do have the right to disclaim warranty or warranties on work on service contracts. And that's what we have here. It's clear terms. And the other argument is that this is a single contract, single transaction. You can't split it into 5 separate breach of contract actions. It's all one transaction. And as to the third,
the remedy on that would be that all those would have to be combined into one count then, right?
Correct. But then you still have to address the waiver of the claims by way of no express warranties. His whole case is the shoreline project was not done to workmanship quality. That's a breach of contract. It's risen from one contract. But you still have to address the economic loss doctrine as to count 7. We're now suing in negligence. And under Nybarger, it's really clear where you have your duty that rises from a contract and no other source, you're stuck with your breach of contract actions. And under count 6, implied warranty, again, there is no implied warranty because this is a service contract, not a goods contract. And under the warranty, which he does not warrant any as to the shoreline project, it must be dismissed. So for those reasons, we're asking the court to find and rule that counts 1 through 7 should be dismissed on the grounds that you can't bring a separate negligence action when the case arises from contract. There's no implied warranties on a service contract, and there's no breach of contract action because the parties negotiated in good faith and ruled that out as an action for shoreline because we set the risk to that of the buyer and not the supplier.
Okay.
Thank you.
Okay, thank you, Mr. Martin, and you'll have rebuttal argument as well, if you wish. Mr. Garcia, your response, sir?
Afternoon, Your Honor. What I don't understand from this discussion or argument that was just made is that they can say is we can construct this rock wall in any manner that we want. It could be 50% of the size it was supposed to be. It doesn't matter if I do it correctly because there's no warranty. And the minute I stop this construction, I walk away and everything else is under a warranty. And therefore, you can never, no matter how bad I do, no matter how crappy my construction is, you can't sue me for anything. And this could have been 3 times worse. And they'd say, you can't do this. My claims in the plaintiff's complaint relate to the construction of the rock wall. It doesn't have anything to do with a warranty that happened. It got, things went bad 3 years later. This was that when they were constructing it in August of 2024, they didn't make it long enough. They didn't make it tall enough. They didn't remove the trees. They didn't
So what about, I think I'm in large measure persuaded by your position that the counts 1 through 5 breach of contract are not barred by the mere disclaimer of a warranty, because breach of warranty and breach of contract are different legal theories. But what about count 6, breach of implied warranty?
And I believe that Barger, I believe is the name of the case law that is relied here, is between a commercial buyer and a commercial seller.
Sure. I agree that's a distinction in that case, but
Right.
Here in the contract, there is an express disclaimer of any warranty about the shoreline.
But that was an express warranty, not an implied warranty. I believe that there's a difference.
So this is you're asserting an implied warranty, a breach of an implied warranty that the goods provided were suitable for their intended use?
Well, that's correct. There wasn't enough, not enough goods. They didn't put in enough rocks in order for the wall to be the size of which the contract required.
Okay. And what about count 7, negligence? There's not a separate heading in the defendant's brief about that, but he does say that he does argue that count 7, negligence, should be dismissed under C8 and C10 under Nyberger and Ronaldo Construction. That basically this is a contract, a breach of contract case, and that therefore the negligence action should not survive.
Your Honor, I'm fine with that.
All right, is there anything else that I need to know to understand your position, sir?
No, Your Honor, thank you.
Okay. Mr. Martin, any rebuttal argument?
Just that to emphasize, you cannot break down into separate claims for separate damages, 1 through 5, as he did. And as we pointed out in the contract, these were approximations and not certain guaranteed set numbers. So we asked the court, if the court is not going to dismiss all the breach, that it'd be down to 1.
Okay, thank you. Well, the defendant has filed a motion for summary disposition under 2.116C8 for failing to state a claim and 2.116C10 for there being no genuine issue of material fact and that the defendant is entitled to judgment as a matter of law on the claims filed by the plaintiff against defendant LLC. Plaintiff hired the defendant to do landscaping and project at a shoreline that was for some specifications about the length of the work, the height of the shoreline, how many feet the wall face would be, removal of trees within an area. Counts 1 through 5 assert various breaches of that contract, and the defendant argues that under C10, those claims should be dismissed because the contract said that all this was approximate, and also that the plaintiff verbally changed some of the work that would be done, and the defendant's compliance with those verbal changes would insulate them from liability for breach. The court is not persuaded by that argument for a couple reasons. The defendant's position overstates the use of the word approximately in the contract. There are several aspects of the contract describing dimensions for which the word approximately are not used. Other times where the word approximately is used. Normal principles of contract interpretation would lead me to think where the word approximately is used for some measurements but not others, the measurements where the word approximately is not used were intended to be precise rather than approximate. Otherwise, the word approximately would have appeared for those measurements as well. So I don't think that the defendant avoids liability just by the word approximately there. And the plaintiff even points out that even like there is approximately for the total square foot of the shoreline, but the 560, but that the amount as he calculated it falls well short of that. So it's not even within any sort of reasonable interpretation of the word approximate. And also the defendant has not, discovery is still open, and defendant has not come forward with deposition or affidavit or documentary or photographic evidence to support some of these factual assertions. And they are flatly refuted, or they're flatly denied by the plaintiff. And the plaintiff points out that verbal change orders aren't even allowed under the contract. They had to be in writing. So I think that the C10 motion must fail for defendant not having satisfied its burden under the court rule. The defendant also claims that counts 1 through 5 should be dismissed or consolidated under C8 because it's all just one breach of contract. I don't know. There wouldn't really be any duplicative recovery. It's not as if by asserting 5 separate counts of breach for each separate manner in which the performance fell short in the plaintiff's view. It's not as if by doing that, the plaintiff's going to double dip in recovery. And I think that's more sort of a stylistic approach, which frankly, I see some merit to, rather than trying to sort out, as I often see sometimes a count that's just too messy and unwieldy because it asserts too much. Here, the plaintiff has asserted rather discrete breaches, and I'm not sure that the law would prevent him from doing so. If I enter into a contract with another person and they breach the contract in 3 different ways, I don't know that means that I'm limited to one cause of action. So I'm not persuaded that those 5 counts broken out cause any prejudice to the defendant or that they're legally barred. So I would deny the motion for summary disposition under C8 and C10 to counts 1 through 5, breach of contract. However, I'm going to grant the defendant's motion in part then as to count 6, implied warranty, and count 7, negligence. Do I have that right in terms of the count numbers?
Yes.
Okay. In that this is a breach of contract for largely for landscaping services. There are some goods and materials that are provided, but it's really a services contract. He didn't contract for them to drop off a bunch of stone and materials. He contracted with them to do this work, and they also provide some materials in the doing of it. So I think it's a breach of contract case. Plus, the contract has an express disclaimer of any warranties. So I do believe that under C8, the implied warranty claim cannot survive. And likewise, the negligence claim. This is a contract matter, not a tort. So I'm going to grant your motion, Mr. Martin, in part, and deny it in part. Counts 6 and 7 are dismissed under C8, and you can submit an order to that effect. All right, and then we also have, Mr. Martin, your motion to strike a notice of deposition directed toward you and your predecessor counsel?
That's correct, Your Honor. The defendant moves to strike the attorneys from being subject to deposition. In plaintiff's response, he says, well, in an initial disclosure, Mr. Martin uses himself in the first person, I throughout. That's a narrative as to the employee. And so a common sense reading would be, it wasn't me, it was the defendant. I have no actual knowledge, wasn't there. I didn't come in.
Some of those assertions that were in the first person predated your involvement with Casey.
Exactly. And then Ms. Beattie, she was counsel during all of that, and that would be entirely attorney-client privilege communications and work product.
Okay, thank you. Mr. Garcia?
First of all, when you have 55 I's, me's, and my's in 4 pages, it's clear that Mr. Martin did not reread what he was signing before this was filed. No one makes that many mistakes.
I don't know that it was a mistake. Maybe he's saying today that he just assumed that you would recognize that that's, a narrative from the, from the employee that has that knowledge.
I don't know who that would be.
I don't know. I mean, you're familiar with the phrase "too clever by half"?
I do, Your Honor.
That's sort of what I thought of your argument about that. Like, you could pick up the phone and solve that issue with Mr. Martin too, right? And said, hey, you don't mean I mean you.
We do not have that type of a relationship that he would not even answer the phone.
Well, all right. But I mean, clearly, it's not him saying that. So why do you need to take let's leave that aside.
Yep.
Why do you need to take Mr. Martin's deposition?
I want to know whether there was actually any of it was him or not.
Why do you want to take Ms. Beattie's deposition?
Well, this is a little bit different. Ms. Beattie is actually listed in the initial disclosures as being someone who has an individual likely to have discoverable information. Now, in that case, they're saying this lady has discoverable information. Not that all that she has is everything, that it's all attorney-client privilege. You can't do anything. The defendant is admitting that this lady has discoverable information, which means I should be able to depose her. Because if they're telling me, and they're telling you, because it's right here in the, in a pleading in the courthouse, that she has discoverable information, I should be able to decide and figure out what discoverable information she has.
Your Honor.
Okay, thank you. Anything else I need to know to understand your position?
No, Your Honor. Thank you very much.
Your Honor, we mentioned her in the initial disclosure in anticipation of the importance satisfaction res judicata motion that this court has already ruled on. Beyond that was it, and it was initial disclosure. That's why I put her down there. She's not on our witness list.
Okay.
And I'd like the court to understand that we don't have this relationship because when I got off the elevator and saw him standing, I went and asked, hello, introduced myself, Mr. Garcia. He looked at my hand and he walked right away.
Okay. Well, I mean, it's not my job to police.
No, but I just
that
wanted
relationship.
the record to be clear what happened.
Okay. All right. Well, I'm going to grant the defendant's motion to strike the notices of deposition of Mr. Martin and Miss Betty. The only asserted reason for Mr. Garcia to take Mr. Martin's deposition is, as I kind of read his response, really trying to set up a possible grievance or complaint for sanctions or something. And that's not really, I'm decidedly uninterested in sideshow fights. This is a breach of contract case on a landscape project. I'm very much interested in the proper adjudication of those claims. I don't see any proper purpose that's been asserted to take the defendant's lawyer's deposition by the plaintiff, so I'll strike that. Also, defendant's prior counsel, Miss Betty. Now that I do think Mr. Garcia was, I think it's a shame that there isn't the relationship where I know Mr. Garcia is representing himself. He's not licensed in the state of Michigan, as I understand it, but he is an attorney in another state, and attorneys generally can sort those things out by way of phone calls. But if that's not happening, it's not happening. But he sees Miss Betty on an initial disclosure list as having discoverable information, so he includes her in a deposition notice. That's not improper. But based on the representations today that why she was placed on that and that she's not on the witness list and she's not in possession of non-privileged information that'd be relevant, I'll grant the motion to strike that as well. And that's without prejudice, Mr. Garcia, to if you determine that you have a legitimate need to take the deposition of an attorney in this case seeking non-privileged information, I'd expect you to file a motion for leave to do so. So I'll grant the motion to strike them and indicate that you can't take the deposition of any of defendants' attorneys absent leave of the court. And if you establish a legitimate reason, we'll address it at that time.
One more item.
Yes, sir.
Apparently, the witness list that was just referred to by Mr. Merlin, this was filed on June 26th. I haven't received it yet.
I don't know if I have.
So it's hard for me to respond to it. So I don't know whether or not I'm going to need additional time to find if there's new people on this list, if we need to get a 30-day notice of depositions. When this finally ends up in my mailbox somewhere, it might be coming to you simply because I don't have it, and it was just filed.
Oh, yeah, I don't know if I see it in this court file yet. Oh yeah, here we go. Defendant counterplaintiffs witness and exhibit list filed June 26th. So if you want to stop down to the clerk's office and grab a copy, you can certainly do that if you want us to look at it now or just take a peek at it.
That was sent to 700 on Hunter Road.
It hasn't arrived yet.
Okay. All right. Well, we can, Mr. Martin, you can prepare orders.
I will do so.
And when we go off the record, if you just want to come up and take a look at the court file, you can look it over right now.
Thank you.
All right.
And Your Honor, it's my motion as to counts 1 through 4 or 5, that would be without prejudice, so I could come back.
Yeah, I mean, I think that's all. I think
Okay.
those rulings are always good.
Thank you.
Okay, thank you very much.